Are you the same Ariana Yalen Fuentes who was placed on deferred adjudication in 2020 CR 7593 for the offense of theft from a person on June 2nd, 2021 for a period of 3 years and extended for a total of 1 year? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor, violating condition number 2, on or about the 29th day of January 2025 in Bear County, Texas. The defendant, Ariana Yellen Fuentes, did in there fail to submit to drug testing as directed by the court officer or supervision officer and or the duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
Where you remain violating condition, Your Honor.
Any objections to the
Objection, Your
waiver?
Honor. No objection.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 180 days in this, I'm sorry, up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court would find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor, and it's continued the individual on probation and denies the motions, with alternate amend to put a hair follicle upon release and monthly urinalysis. Also for her to provide a good address where she was living. And also sober support meetings weekly for 60 days. And then also we requiring or requesting a 6-month extension.
All right, thank you.
Thank you, Judge.
Yes.
And again, we are in agreement with that. And just like to point out to the court, she has completed her direct class. She got her GED with the first couple of months on probation. She's paid all her fines and court costs and everything, and she's been clean for 8 to 10 months, which the hair follicle should show that. So we are in agreement with the
Well,
recommendation.
why isn't she doing her UAs?
May I speak, Your Honor?
Yeah, can you raise your right hand?
Yes,
Do you
ma'am.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Ariana Yalin Fuentes.
Yes, why are you not reporting for your UAs?
So I am currently a full-time student in Academy for Massage Therapy School, Your Honor. And it revolves all of my time and all of my day. I go to school from 8 in the morning to 2:30 I'm in class. And then after that, I attend internship from 2:30 all the way to 10 at nighttime.
Mhm.
So I'm constantly busy at school. The only day I do have off is Sunday. So by the time that comes, I don't really have time to do anything. And I'm on a call line. So the call line that I call, I'm at school. Sometimes I'm taking 2 tests a week. So I'm busy. My main focus is on
So
school.
here's the thing. I understand that people have other things they want to do. They're busy. But when you're on probation, you're on probation. I don't know what people don't understand that probation should come first. I know people are trying to better their lives, but probation should come first. And she's been here before and I've altered and amended conditions for her before. And I've asked her to do sober support meetings. Did she do those?
No, Your Honor, I did not. I know it's not an excuse and I agree that probation does come first, but I've been trying to fix my life and I have a goal to open up my own business and
But
start.
here's the thing, they're asking for you to do sober support meetings. I've already ordered sober support meetings. And there's no excuse for not having done those because sober support meetings, they're available 24/7 throughout the city. They're available on Sundays, they're available Mondays, Tuesday, Wednesday, Thursday, Friday, at all times of the day. So I don't even understand why probation is recommending that she do sober support meetings. I've already did that. She didn't do them. I've already extended her. She didn't do well. I already asked for weekly testing for levels. And I will tell you, the only reason why I would ask for weekly testing for levels is because she's using. If she wasn't using, I wouldn't have asked for levels.
She insists she's been clean for 8 to 10 months, which, like, again, the hair follicle will show that if that's true.
Well, I mean, we would have known that if she would have done the testing. I don't think probation is a good fit for her.
And Your Honor, also, I'm on a call line, so I'm on random drug tests as well. So I'm not sure. I don't know whenever I take a drug test. It's not like I intentionally.
No, that's what it's supposed to be. It's supposed to be random, so you don't know because there are
Oh,
some
yes, ma'am, I
drugs that stay out of your system. And what's the number one thing I always tell people? I always tell them, if you have an issue with probation or things are going on and you can't do something, come to court, let us know. She didn't do any of that.
I actually tried to reach out to you plenty of times through my probation officer.
No, I already said, if you have an issue with probation, you can come to court. Do I not say that all the time?
All done.
So I don't think probation is good for you.
But she
I-
did, I'm sorry,
Go ahead.
she did ask her probation officer if she could have a meeting set up with you, the court to talk to you, several months ago, I guess.
Yeah, my probation.
She
I
did
was
reach out
trying
to her.
to talk to you about all my achievements and stuff that I've been completing and let you know that I've been doing good.
Mhm.
And I know I missed a few calls. It wasn't intentionally, like I said, I don't.
No, I mean, even, here's the thing. You're in school, you're doing whatever, I understand. But there's no reason to be missing the sober support meetings because they're available 24/7 throughout the city.
I would be like, it's not an issue that I can't do it. It's just I'm in a school where I do a whole year of education in 6 months. I'm a slow learner. I have to study 2 times, 3 times harder than usual.
Mhm.
So it's harder for me, but I've been putting my time and my effort into this. And today I was supposed to graduate today on the 7th. Today is my graduation. But I'm here.
I mean, you're here because you violated probation. That's why they have a warrant for you. I honestly don't think probation is appropriate for her.
I think she should be given a chance to finish out her probation, I'm pretty sure. And she'll confirm that she'll be able to finish out probation
But I mean, we're
successfully.
here for, I do believe we're here for the same thing that we've been here before. Everything that probation is asking her to do now, that you all have agreed to, I've already given that to her and she didn't do it. And now we're back and they're asking for the same thing. It's not as though we're dealing with a 4-year-old. How old are you?
23, Your Honor.
All right, so she knows. All right. Probation, what has she done on probation? Has she completed anything?
Do I talk about? Oh.
She's had probation.
That she needed, the reentry program with turning points.
Mm-hmm. Well, I mean, because those are waived if she completed Turning Point. Okay,
I also, may I speak, Your Honor?
yes.
I also got my diploma as requested.
Mhm.
I paid off all my fees as
Mhm.
well.
Oh, the fees aren't paid off during the spread.
My address is up to date. I understand that they haven't been able to come to my house, so I'm at school. I have proof that I'm at school. I have my progress report with all my grades.
All right, state. I don't think she's appropriate for probation, but I would consider a 1244
Okay, Judge,
if there's no objection.
no objection.
All right, the court is, yes, okay. All right, do you want to explain to her about 1244 and ask whether or not she's waiving her right to appeal?
Do some time.
Well. Judge, how many days would you consider? I don't know how many days yet. How many days is it? Gets 30 days credit, so we're asking for 1244 for 30 days, judgment set.
No, Judge.
Right, what I'll do is, I'm not gonna do the 30 days, I'll do 60 days. Give her credit for any time served. Is she waiving her right to appeal?
Yes, Your Honor.
All right, the court is finding violation of condition number 2 true. The court will grant the motion, find you guilty, revoke. Sentence you to 60 days in the Bear County jail, jail under 1244, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor. I have a question for you. Oh, go ahead, sorry.
No, Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, yes, Your
All
Honor.
right, so here's the thing. Bear County Jail, they give people sometimes 2 for 1. I'm not in charge of whether you get 2 for 1 or not. The only thing that I can do is I could put on the directive, this person is to do day for day time, which would mean you would have to do the full 60 days. I'm not doing that. What time you get at what credits you receive from the jail, that is strictly up to Bear County Jail. So if Bear County Jail wants to give you 2 for 1, that's up to them. What I can tell you is, if you're not a trustee, trustees usually for every day they serve, they get credit for 3 days. It appears you're not in red, so they're probably going to give you credit every day is 2 days.
Yes, Your Honor.
Anything else?
So does this mean I'm gonna be a felon?
Yes.
So is there a way that I can get this off my record?
You have to speak to your attorney.
Okay, thank you, Your Honor.
You're welcome.
Maybe she's,
Yes.
thank you.
Okay, I guess that was the part where I was supposed to start talking. I'm still stuck in chat. Hey, everybody, welcome to American Courts. We've got a bunch of fun stuff going on today. Since we've already got Nancy in the crowd, let me go ahead and do something I'm supposed to do. Nancy, pay attention, Nancy. I'm only going to do it once.
Happy birthday, Nancy. This one's for you.
That was for you, Nancy. That's Fozzie, Nancy, in case you don't know who that is. I had to look a couple times to realize who it was. All right, here we go with Judge Mogan.
We will go on the record in the matter 24 FO 275, Town of Menon versus John Armstrong. The Town of Menon appears through Chelsea Whitley by video conferencing. She was on her way to court to be here in person, but the weather is now in a terrible state, and she had to turn around in luck because she could not get here safely. So she's appearing by video. John Armstrong appears here in person without counsel. We're set today for a court trial. But before we begin, I do have to bring something to everybody's attention. Mr. Armstrong, I believe I need to recuse myself from this case because it's been brought to my attention that there's been numerous postings that you believe that I'm.
All right, I'm going to hit pause on that real quick and mention it. Kelly Fitz, if she's here tonight, I don't know if I've seen her in there. There's a lot of people in the chat. Kelly Fitz had sent me this, so thank you so much, Kelly, for letting me know about this one. I'd missed it. So you're a rock star. Thank you so much.
Not that I'm biased and I'm not partial, or that I am partial and I'm not impartial, and you don't believe that you're going to get a fair trial and all of these things. And I'm going to tell you that my whole job is to ensure that people can get a fair trial, and that's my job. And also, I also want to let you know that courts don't decide where people live. Courts don't decide where people go after they're done with probation. Judges don't decide that. People don't decide those kinds of things. I don't get to make that choice. And so those are things that I think that people should be more informed of the justice system and know how it really works before they spew things all over, because it's not fair to the people who actually know how the system works. And so I don't care what you say or what you said about me. I really, truly don't. It doesn't hurt my feelings. It's my job. But I want to let you know, and I'll let you in on something that I didn't find out that I had a group home 3 houses down from me until I got a case where there was a shipment, a huge box shipment of THC vapes sent, and I was on that case. But you want to know what? I had to dismiss that case because somebody's constitutional rights were violated. And so as a person, that kind of, I'm like, wow, I just found out I have a group home like 3 houses down from me. And there was a shipment of THC vapes sent to this group home. As a person, I'm like, wow. As a judge, I have to look out for people's rights and their constitutional rights. And that person's constitutional rights were violated. And it is my job, my responsibility, my ethical duty to dismiss that case because that person's rights were violated. And that is exactly what I did. That is exactly
Understandable.
what I do.
This may be a lot different than vapes, though.
Well,
Yeah.
the thing is, I'm not going to get to know because you have already stated on social media, and again, it's been sent to me by multiple sources, that you think that you're not going to get a fair and impartial trial.
Yeah, I sent that letter away when it started. I sent that letter to you.
Well,
As a matter of fact, I sent you a letter 2 years ago that you never replied to or never responded to.
there's such a thing called ex parte communication.
Understandable.
Where judges cannot respond to things by individual people. And there are, in cases, only some people can write letters and do some things. I can't respond to letters that are sent to the court and to be put into a file. I would be able to
Understandable,
respond
yes.
here if we have an actual trial and as a judge. That's where my voice gets to be heard. I
Understandable.
don't get to be heard until that time.
I guess I was sending it out for public awareness. I sent the letter to 3 judges and I got a response from 2 of them.
Well, I don't know.
So here we are. So
I'm going to guess that, well, I don't know. I can actually go and talk to those judges because I'm friends with all of the judges in District 10.
well, I've also brought a witness that he said the state asked for 9 to 12 months and he was out in 3 months. And there were 2 roommates
Here's the thing.
that are
Here's the
pedophiles
thing.
in his house.
Here's the thing that you don't understand about the law. There are higher courts that direct what courts have to do and what I
Understandable.
have to follow.
Yeah. You're not getting all the information.
I know I'm not, and neither are you. And that's what I'm saying.
I've got
And
stacks
that's
of
why
it.
I'm saying I'm recusing myself so you can have the fair and
Perfect.
impartial trial.
Thank you very much.
Believe that you want to have.
Thank you.
And so you'll be assigned a new judge. And then you can have the fair, impartial trial that you wish to have. And however it goes is how it's going to go.
Will I be able to request a jury trial?
No,
Oh, because I requested that earlier,
this isn't a jury trial case,
but I requested it initially. I requested a jury trial.
but it's not a jury trial case.
On the letter from the court said that I had an
Talk
option.
to the new judge and you can make your case
Perfect.
with the new
Thank you.
judge.
Thank you very
And
much.
so that's what's going to happen.
Yes.
But again, it makes it very difficult for the justice system when people don't understand how it works and what happens. I would love for you to come and sit in court, not only my court, in every court. Go sit in Polk County Court, go sit in Washburn County Court, go sit in Barron County Court, and see how courts function and how they work.
As a matter of fact, I was sitting here for Randolph Peckman's sentencing that he didn't show up for.
That wasn't my case.
Yes, it was. You were,
It was John Anderson's case.
he didn't show up.
It was Judge John Anderson's case.
And so there was a warrant out. The warrant got squashed and then the charges were dropped and he's back in the house and the windows are boarded up.
You can go and look at the back. It was Judge John Anderson's case because he took that case. So, know the
Well-
facts.
Okay, well, thanks for your time.
I issued the warrant, yes, because he didn't show up. But that's what happened after that, because I issued the warrant because he didn't show up.
Yeah, I actually gave you his address in court because you didn't have it. And so I asked Finch the next day if a warrant went out. She said no, she hadn't heard nothing. And then 5 days later, the warrant finally went out. Meanwhile, he was gone across the country. This is,
I issued a warrant. That's all I can do.
yeah, well, who squashed it?
First of all, it's not squash. It's called quash.
Oh, okay, well,
Squash a warrant.
I got a message from,
Again,
Uh.
follow the cases. Come and sit and follow all of the cases, and then you can learn the information. I don't know what's going on here because I don't know anything, because that's
Of
what I do.
course, yes.
My job is to sit here and to hear about your case and to hear about from town of Beanon.
yes,
I know nothing about what's going on in this case. I know there's a citation. That's what I know.
thanks for giving me the opportunity. I was able to watch your video the other day, and respectfully, I feel for you guys. What I got out of it is that silence is cancerous and it's deadly. And that's what's been going on for 2 years. Silence. I've been silenced by everyone.
Well, you're gonna get your chance to be heard, and
Thank you so much.
you're gonna have a new judge, and hopefully it's gonna take place soon. So Ms. Whitley, I will get the documentation done, and also though, you need to have it in person. Ms. Whitley should
Yeah,
be
no
here in
problem.
person.
Yeah, I understand the situation. Yeah, I was surprised that court continued today because the roads are terrible.
I'm gonna tell you, I've been sitting here since
All day.
yeah, all day, and I don't know what's going on.
It's terrible. Yeah. All right, thank you.
So, thank you. Thank you, Ms. Whitley.
Yes, I apologize. Thank you.
All right, so that guy's being a good guy. So we got he's talking about how bad the roads are, and I keep thinking about how good the weather is here. I got a friend of mine, she was saying it was only 50 degrees today. It's damn near it's April. What time do y'all stop having bad weather up there? I can't figure it out. We've got let's go to Judge Hakeem and another Michigan judge here. Let's go.
Richard J. Goodman appearing on behalf of James Hall, Your Honor.
And who's here from CFP?
Andrea Vandenberg, Hospital Director, Your
Okay. And Ms. Vanderberg, I am sorry you are caught in the crossfire of who they decided to send here today for the show cause. And I understand that you are the hospital director, and show cause, really it should be the head of CFP, not you, who is just someone who is doing the best you can, and I'm sure and I'm cognizant of that. That being said, this is the second time since I've been on the bench that I have had to show cause the Center for Forensic Psychiatry for writing reports that find people incompetent. This man was found incompetent 1 year ago on April 24th of 2024. This man was kept in custody pending placement in a hospital. CFP has assured me that if I keep someone in custody, they will get placed faster. And by releasing them, I run the risk of CFP putting them at the bottom of the list, to which point they're never getting placed in for treatment, because as it is known, once a person is found incompetent, there are 15 months to restore that competency. 15 months is 1 year and 3 months. So CFP says, if you keep them incarcerated, we will place them faster. If you release someone, it will take longer because we place in custody defendants faster. I don't use that as a method to decide of whether or not to keep someone in custody. I honestly take everything on a case-by-case basis as to whether or not someone should remain incarcerated, as to whether or not they continue to pose a public safety threat to the public, or a return of court concern. So those are more the factors I look into. So I have released people pending CFP placement that I don't believe are a concern for either of those factors and are waiting for a hospital bed, because I don't believe there's proper mental health treatment being given in any jail in the system that we have here. That being said, this man was kept in custody, and yet 1 year in, he was still not placed into treatment. So I'm concerned about the disconnect of CFP telling me that if someone remains in custody, they're going to be higher on the list and be able to get treatment faster. And I am not unaware that there is a massive mental health problem that is a much bigger scope than what I am going to ever be able to solve in my courtroom here in the 39th District Court. And that is a much bigger scale issue that is happening with our lack of mental health treatment services that are resulting in a multitude of people entering into the court system that probably don't need to be here, because their underlying mental health issues, there's no access to be able to treat that. I understand that that is a broader issue than we are going to solve in my courtroom this morning. That being said, I would think that with a 15-month time period, if the faster route is someone remaining in custody, and this man sat in custody for a year on a 15-month time period, I'm not sure how that is any sort of faster route, or that we're doing any services to get anybody placed into treatment. And I understand that the hospitals are overrun, and I understand that, ma'am, you are only here as a director of the hospital, and they threw you under the bus today to throw you into me because they didn't want to come back to me because they've already been here and they've already heard me. That being said, I am now aware that 2 days ago, Mr. Hall is now placed into a hospital and into treatment. And shockingly, this is the second time I've show cause the Center for Forensic Psychiatry. And this is the second time that 2 days before the hearing date, magically a bed opened for the person I show caused for. So I don't know where I'm supposed to go with that as a judge. Do I wait 3 months if someone's in custody and say, well, if they're not placed in 3 months, I'll show cause? Because I swear if I show cause, apparently we magically open beds available for people. So I'm not trying to cause a massive disruption or act like I don't understand the broad scope of the overall issues here, which are underfunding for mental health treatments, lack of resources, lack of access, lack of hospital beds, and lack of things that are well above your pay grade and my pay grade. So I do understand that. But at the same time, we have an obligation to service people. And if we are going to deem them incompetent and say we are going to provide services to restore that competency within a certain time period, I believe that we are doing a disservice and we are not upholding our obligation.
All right. Hey, all the Big and Raiders. Thank you guys so much for coming over. What we got here is we got a Roseville, Michigan courthouse, Judge Hakeem. Someone was determined to be incompetent and they had 15 months to restore their competency. They sat in jail for over a year without getting a bed. She ordered a show cause hearing, and magically the day that they're supposed to give an answer, they give the person a bed. So she's just giving them hell for not doing their job. They probably don't have the resources, probably don't have the manpower, probably don't have the care. So she's just doing what she can, and they're catching an ass chewing. So here we go with that.
If we are having someone linger in a jail for a year where they are not getting any services for an entire year, nothing is being addressed. Nothing. I would have better luck releasing somebody and having them go to community mental health and finding services on their own at that point, because all I'm doing is cycling them in a system that's doing nothing for them. And the whole point of having this ability to look at someone's competency and address it is to be addressing it. So I thank you for being here today, because today is now a moot point and a non-issue, because magically Mr. Hall got a bed 2 days ago, and I really hope he's getting the services that he needs to restore his competency. But if I continue to have people linger in the jail for almost a year, I will continue to show cause CFP as to why. And I think that's only fair to keep a check on the system to make sure that we are actually servicing the people that we claim we are supposed to be servicing. And the whole reason we are finding them incompetent, because otherwise there's no point to me even sending referrals or considering someone's mental health. But the problem is, if I don't consider someone's mental health, that is the entire reason 90% of the people end up in court before me. So I'm doing nothing and I'm serving no one sitting in this position. I appreciate your time today. I appreciate you listening to my lecture, because understand that this was not for you, because I know that you have nothing to do with this and you are here today with literally as their scapegoat. But feel free to pass on the message, because I'll just continue to show cause if people are going to linger for a year, and they can continue to report to me. And at some point I'll be fining CFP with contempt charges, because I don't know what else to do to get the message across that I understand there's time. And I'm not saying someone's found incompetent, they're going to get a bed the next day, but a year is unacceptable in this court. I appreciate everyone's time today. Mr. Goodman, thank you for your time as well. Your client's been placed. We'll let you know an update. We'll set a review on this matter, and we'll set that review for 45 days out at this time. Mr. Goodman, why don't you pick me a date late May, early June, whatever works in your schedule at 8:30 a.m. on Zoom.
Oh, it has to be on a Wednesday, or?
It has to be on a Wednesday. Work within your schedule. You tell me. Late May, June. I mean, we can go 90 days to July if that's what you'd like. I'd like to keep, I'd like to keep it somewhat just so that we're getting a check on things because his 15 months is going to expire in July. So I don't want to go too far out.
How about June 4th?
June 4th is fine with me. Ma'am, thank you for coming today. Like I said, I am well aware that you were just the scapegoat sent here. You have a good day.
Thank you, Your Honor.
Thank you, Your Honor. The other question my client was going to ask that I'm anticipating is that they have him on 23-hour lockdown at the jail. He was going to ask the court, or I'm requesting the court, and I don't know if you have any discretion in this anyways, is to allow him to be moved back to general population.
So I wish I could do things and the jail would listen to me. But I have no control over the jail or how they do any of that. I barely have control over whether or not they'll zoom into my courtroom on an average day. So that well exceeds my authority.
Right.
However, I am going to also refer your client for a community substance abuse assessment just so that we can see if he needs any services. And I am going to order that if he does bend out, community corrections is to provide financial tether assistance.
Thank you, Your Honor.
Take some of that burden off of him. Okay. And good luck with that, sir. I have no control over where the jail places you in their facility. I'm just happy when they zoom you here.
Mr. Jordan, do you still have a question or no?
No, that's it.
That's what I figured. All right.
You guys
Thank
are all
you.
set today.
Thank you, Your
You're
Honor.
welcome.
Thank you, Your Honor.
Well, my next court date is what? Is when? April the what?
April 14th, sir.
Okay.
All right, everybody. Again, it's Nancy's birthday today, so we want to make sure to say thank you to her. The Big N guys weren't here, so thank you so much for coming. We're gonna throw Fozzie on again, and then we're gonna go to Judge Fleischer today. Judge Fleischer had a very, very, very emotional case. It had a victim impact, and I don't really know what to say about it other than I'm proud for the lady to be able to stand up and speak, and I'm proud for her to be able to be heard. I don't know that she was listened to, though. She spoke, but I don't know that they really heard her. I don't know that justice was served, but hopefully she'll be able to find peace in it. But we're going to jump to the Fozzie thing, and then we'll go to Judge Fleischer, and we'll see how that turned out.
Happy birthday, Nancy. This one's for you.
Okay, Mr. Johnson.
Just more.
Put your hands on your side. Hi.
Mike, I see you.
Yeah, great to see you. What's new?
Judge, this is a plea. It was a felony case. We refiled it as a misdemeanor.
Okay.
And there is a victim impact statement. The victim is not present. So I was wondering what the court wanted to do.
I don't want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time. Because I want that person heard as well. It's only fair. So.
Oh, this was one where it was freezing a little bit too. So let's bump it so we're together.
It's the whole purpose. No, can you reach out to her real quick and just see? I know you're in the home stretch, dude. I mean, I know you've gotten a great deal here.
And there did it again. I'm gonna bump it up again and get out of that.
Can you hear me?
This is the part where they're getting the victim for the victim impact statement.
Miss Echevarria. So,
Oh, hello. Can you hear me?
yes, I can hear you.
Okay.
Okay, give me 1 second, ma'am. Give me 1 second. So procedurally, with this case, Joe, he gets charged with a sexual assault upstairs, or he's on bond for a sexual assault.
On bond.
And then he picks up an indecent.
No. Plea bargain down to a class A indecent assault.
The felony court does not do misdemeanor probations, so we had to refile it as a misdemeanor. That's what the plea deal was essentially.
So it was a reduction to a misdemeanor,
Correct.
indecent assault
Correct.
to a 2-year defer.
Correct.
Okay. So let's do ma'am, what I was going to do is do the plea first and then have you say something after the fact, if that's okay. Are you okay with that?
Only if it's not allowed for me to speak first prior to the plea, then of course, yes, it's okay to speak
If you want to
afterwards.
speak first, then you're welcome to. Is there something
Okay.
that you wanted to say?
Well, I wanted to read my victim impact statement.
Please do. You're welcome to do it.
Okay, thank you. Okay, so I'm writing this statement to share how this experience has continued to affect me long after that night. There may be times where I actually need to take a moment to breathe, actually. Just wanted to go ahead and say that first. When I first submitted this statement, I was overwhelmed. I was still in emotional shock and unsure of what to say and how to say it. I've since come to understand the importance of expressing clearly, not just what happened, but how it impacted every part of my life. This event has completely changed me. I wake up with anxiety. I experience episodes of fear, confusion as to why I did not run, and constantly feel a loss of trust, not just in people, but in places I once felt safe and in myself. Every day I'm reminded of what I've lost. I lost peace of mind. I lost the ability to work without panic, the ease of everyday interactions. Every day I'm reminded of how I got taken advantage of and didn't react as I felt I would have in a moment like this. If this emotional toll has affected my professional life, my relationships, my physical well-being, I can't control my heart rates in these moments of panic. There are true anxiety, full-on panic attacks that I experience still to this day, 2 years later. At the time of my first statement, I didn't have access to important documents, which are records that might have helped me explain myself more clearly within these 2 years. Since then, I've started the process of requesting my full case file from multiple agencies, medical records, and forensic testing. I have not received those as of today just yet, but I know those documents all exist. It's been over 2 years, and this case has been reset multiple times. A new prosecutor was also assigned only days before this plea was suddenly brought to me. The rapid timeline did not allow me to revise my statement or consult with anyone about how this offer would impact my rights as a survivor or my potential ability to seek justice outside of this criminal court. This statement is not about vengeance. It's about the truth. It's about my healing. It's about ensuring my voice is heard in a process that often feels designed to just move forward without it. Every day since this assault, I've struggled with anxiety, flashbacks, and trust issues that have reshaped how I live my daily life. I still cry regularly from this incident. I still shut down. I still replay everything from the pressure, the coercion, the force, the aftermath of where I try to survive it all without falling apart. And yet I still feel like I have to justify why it broke me. This wasn't just a violation of my body. It shattered my trust, my sleep, my ability to feel safe in my own skin. I've spent nights replaying what happened, and the fear and the disgust and the betrayal. What was taken from me was not just physical, it was psychological and it was spiritual. I'm a hairstylist, and my career is built on one-on-one trust with my clients. Since this happened, I've felt constantly on edge with male clients. I find myself backing away from simple interactions. I've lost my income. I've lost my confidence and my own safety in my own body. The job I once had, I lost due to being completely disconnected from my mind and my body. I now know that this man was on deferred adjudication and had a breathalyzer in that car. And yet that night he took his mother's car and drank heavily and violated me when I was in and out of consciousness. The defendant slapped my face during intercourse and violated me. His third time assaulted me that same exact night without consent. I remember him begging me again and again, and I kept saying no. But I couldn't get up. I pushed him away off of me again and again. That is not consent. Me freezing up was fear. That was survival mode that I was going into. And Your Honor, I ask that you consider what kind of system lets someone walk away with that and just probation. Even after all of this, I still had to let him drive me home the next day and bought me a Plan B pill. The defense says I had chances to leave, but how do you leave when your body and your brain have been hijacked by fear? The prosecutor told me that juries don't like women and that they don't believe us, and that broke me more than anything. I was told I could be blamed at trial for going to the bar or for texting him afterwards, as if trauma survivors don't respond in ways that help them stay alive. That's why I'm asking you now to please understand that this proposed plea is not justice.
Then I'm not gonna take it. I'm not taking it, Joe. I'm not doing it. Sorry.
Just
I
because
have
she
more-
spoke first?
Oh, I mean, I don't know. All I know is that we have a powerful victim impact statement here. We have a sexual assault being reduced to a misdemeanor, 2-year deferred. Apparently, no one's consulted her regarding this thing, you know, see whether they.
We have been in extensive communication with her this past.
No, sir. No, sir. I
about the plea
barely
and
spoke
reasons
to you
for
a
it.
couple of days ago, sir. I didn't even know you were on my case until Tuesday or Monday it was Tuesday when you first called me. I didn't even know Missy was not on my case anymore. And she gave me the confidence that this would go to trial. She believed we had a very strong case to bring this to trial. She didn't have any doubts in this case at all. And I meet Gabe just this Tuesday. And it's rushed into this plea without even without even discussing with me.
Okay. Thank you, Ms. Echevarria. I appreciate your testimony.
I really appreciate your Honor letting me speak before you accepted this plea.
Absolutely. And I'm glad that you were here to speak, get everything off your chest.
Yes.
Anything you need, we're here for you, Ms. Echevarria.
I really appreciate that, Your Honor. Thank you for letting me get on Zoom, even though I could not physically be there.
Yes, ma'am. I will accept this, but I'll do 30 days as a condition. It's the only way I'm going to do it. So you guys can talk and see if that's something
I
that
think
you
it's
want to
unfair to
do.
my client because normally we do the plea, then we have the statement. Just because she spoke first, now she's gonna bust the deal?
She's not busting anything. I mean,
I'm
I
the
was,
victim. I am the victim. How do you even
Please.
speak about? Sorry.
Please.
Yes,
It's
Your
okay.
Honor.
He's been coming to every court date. We've been set for trial 7 times. We're actually set for trial this morning.
In the district court.
I'm sorry,
In the district court.
in felony district court.
I get it. She feels like, you know, one of the things that we need to take into account, you know, is I'm not going to do it without 30 days as a condition. I'm sorry, Joe. So you guys can talk and then, or we can set it for trial. It's your decision, Mr.
You do home confinement?
Home confinement? No. That's a gift. No.
All right, can we stand up?
Please.
Okay.
Okay, ma'am.
It's only 10 days, just, 10 days. Otherwise he loses his job.
It's better than the current deal from our perspective.
Okay.
Thank you, Judge.
Good.
Okay. Come on.
And also, Judge, the complainant did not finish her impact statement, if she could be allowed to do that.
Yeah. Let me do this first. We'll go through with it and then. So, Mr. Camano, I'm also putting on a protective order as of today. Mr. Camano, you're charged with indecent assault. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 2-year deferred with thinking for a change, sexual boundaries course, 50 hours of community service, no contact with Ms. Echevarria, and 10 days as a condition in jail. Do you understand?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
You are giving up the right to have a jury decide whether you're guilty or not. You're giving up the right to cross-examine any accusers, confront any witnesses. You give up the right to appeal. Once you accept this agreement, you can never get out of this. It will continue until you complete this agreement, or if you violate it. If you violate it, I will issue a warrant for your arrest. I'm going to bring you back over here. We are going to have a hearing whether you violated this, and if you do, you're looking at an entire year in jail. Do you understand?
Yes, Your Honor.
If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
The U.S. citizen, Judge.
Okay. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold that for 2 years. You will be required to do the thinking for a change, sexual boundaries, 50 hours, community service, no contact with the complaining witness, no weapons, no drugs, alcohol, random testing. I want him tested in a week, please. If you're using, it's not going to go well. I'm going to tell you now, I'm going to test you like crazy. If I find that you're using, you're going to get a one-way ticket. Do you understand?
Yes, Your Honor.
Okay. Ms. Echevarria, did you want to say something else?
Yes, I'd like to finish my statement, please.
Okay, you may continue, ma'am. Shh.
Okay. Sorry, let me get back. Okay. I was 2 years up. Okay. So I have submitted requests to the HPD, Houston Methodist, and the Forensic Center to access police reports, my toxology, and my rape kit results, all things I should have had years ago. I just began accessing public records on my own because no one helped me understand I had the right to review them. And this is why I wanted to request a continuance. I do respectfully request that the court do require the conditions that prioritize accountability, rehabilitation, and safety, such as formal admission of guilt in court or via stipulation, no contact, and geographic restriction order, mandatory sex offender rehabilitation, and language in the plea agreement affirming that I reserve my right to civil litigation because I want peace and I want to heal and I want to know that my voice mattered. Also, Your Honor, I respectfully request that you do not proceed with that plea until I have had the chance to review the full case file, as well as all the evidence I'm lawfully requesting, including the police reports, toxology, and stain results. I was not given the sufficient time to revise my statement, and I've had to teach myself how to access the records, the court records, after being left out of the process. This case was reset 7 times in the past month alone, and I was promised a trial, not a rushed plea. I'm asking that the record reflect my objection and that my request for a continuance be considered on the basis of my rights under CCP 56A.051 and 56A.052. if the court must move forward with that plea, I would request the formal admission of guilt, the no contact order, required sex offender counseling, and a clause affirming my right to pursue civil litigation.
What I will say, ma'am, I know that you are upset and I'm sorry that you are. I have no idea why it ended up here, but it is. The lawyers, I think, have been working for a while to try to resolve this. They've come up to an agreement. I did issue a protective order now so that there is one in place.
Yes, thank you.
So, and I've also ordered no weapons as well. So,
Is there any way he can have the sex offender counseling? I feel like very much so.
I don't have, that's not something that I have access to down here. That's only in the felony courts. So I don't get access to any of that stuff.
What about the formal admission of guilt from the defendant?
They have worked out an agreement where they're doing a deferred. So it's a deferred adjudication. That's something that you're going to have to get with the office about. I know that you have other avenues of recourse as well. I can't give you legal advice. The only thing that I would probably advise you is just go talk to a lawyer, you know?
And so trial is not able to go forward.
No, the case is done now. It's ended in a deferred adjudication just now, ma'am.
Okay, and he was previously on the adjudication, but what about, I still feel like I'm being silenced with everything that I've been saying.
The only thing I could advise you is go back to the district attorney's office and just start, talking to people there.
To the district attorney's office?
Yes, ma'am.
Judge, our first trial setting was March of last year.
I
This is the first time we're hearing about her asking for anything. And we've
No,
had
I was not.
after setting.
I was not aware. I have all the
Excuse me.
texts of the.
Can you finish, please? We've had setting after setting. This is the first time we've heard anything about this from her. So I don't think that's.
This is not the
part of-
first time. I have
Ma'am, let me finish, please.
requested forms before. I have sent
Well, ma'am,
emails
look,
to get these
Mr. Chevalier,
documents.
I don't want to get into, I don't want to get into a big match about what's going on now. The only thing I can say is if you have any kind of disagreements, get back with the office, talk to go to the district attorneys and go talk to them and figure out what else. Like I said, there are other avenues. I can't give you legal advice. I can't tell you what to do from here. Okay.
Okay.
Is that it?
Yes, sir.
Okay. Thank you, ma'am.
All right. Thank you, Judge. Can we start next Friday?
Sure. Yeah.
That's it. Okay. Thank you, Judge.
Will the court allow me to consult, the opportunity to consult with the victim advocate
Is there a big?
or a legal liaison before
we have a
anything is
social worker.
finalized?
We have a social worker who is assigned to this case as well, and both of us have been in contact with.
So do you have the number to the social worker, ma'am?
She hasn't been that responsive recently. Just coming up to the court date, really.
I'm happy to give her a call this afternoon and we can go over all of that.
Okay, so the prosecutor assigned to this case will give you a call this afternoon to try to help you get in touch with the social worker to remedy any kind of issues you may have, okay? If you still have any issues, you can come back tomorrow and then we can try to resolve it further, okay?
There at the courthouse?
Yes, ma'am.
Okay, will I be, will I be asking for you, for your courthouse personally?
You're welcome to, ma'am. Yes. I'm in court 5. You're always welcome to come here and we'll help you out as much as we can. Okay?
Court 5. Okay, and what exactly was the plea that he admitted to, or the, what is he?
It was a 2-year deferred adjudication
Joe.
with 10 days in jail as a condition.
Okay, oh, so it went down to 10 from 30? I think I heard 30 earlier, it went down to 10?
Ma'am, I can't continue with this. I have a courtroom full of people that I have to get to. I'm sorry. But
Okay.
I will let you speak, or this afternoon, Gabe is going to call you the prosecutor on the case and he can explain everything further to you, okay?
Okay, thank you.
Yes, ma'am.
Valerie, I'll text you as well.
Okay, thank you.
Thank you. Are you waiting on the dismissal still? Is that what you're waiting? Sorry, it's been kind of busy.
All right, so that's awkward. Kind of think I should have planned that out a little better. Had a happy court thing. Had a happy one coming on afterwards. Critter, she was on Zoom, and the judge didn't show the Zoom screen, and that's for the best. Protect her there. She got to be heard. We heard her a couple of times. There should have been somebody fighting for her. There should have been somebody standing up for her. And like, I loved how she called him out, saying that they never heard anything until the day of it. I know plenty of people who have been accused of crimes and they never met their public defender until the day of court. This is the other side of that. In the end, they probably don't have enough resources, but it's there's really no words to say for something like this, and so. I'm sure Judge Fleischer's tore up about it. I'm sure everyone in his courtroom is. I kind of want to put most of the blame on the prosecutor. The defense attorney's got to do his part, and the defense attorney did. I kind of think he's a jerk for talking over her when she interrupted him a couple times, but she's kind of earned that right to get her voice heard. Today was the only time anyone heard her, and they still didn't listen. So, all right, let's look at a couple Judge Fleischers. I got a couple more on here I could pull up too. All right, here we go with this one right here. This will kind of change the tune a little bit.
Judge, you told him not to drive. The allegation is that he was driving. First of all, Judge, I want to speak on when you told him not to drive, it was because the state told you that he had an ALR suspension. What I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed files. This is an ALR dismissal order.
So, okay.
There was never a suspension on his license at all. He's been good to drive.
But he was also drinking.
Well,
The concern was that he was drinking.
But Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
He was drinking allegedly, and the license was suspended.
Yes.
Can you run his license, please, to the state?
It does show to be eligible to.
Did it just become eligible, or when was it eligible? You know what? Let's do this. I have a line of people. I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
had
more
to go
time.
to the doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
I'm already
Let me
here,
look at
Judge. I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
So what day was it lifted?
4/2/2025, from what I can see on the license. NCIC.
And what are the days that he's alleged to be driving?
The second, Judge, let me double check.
Does he have an interlock as well?
Yes, Judge, he has interlock. He was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a lay person who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with this license. There was no ALR suspension ever. The state told you that. That's why you.
It was a suspension.
It was
and
not
it
an
was
ALR
lifted
suspension. There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal order, Mr. Jurisich? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing you.
ALR suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
ALR suspension, if you know, 12/6/2024, end date 6/3/2025, and the lift date comes in at.
And then if that's.
I'm not saying you're wrong, what I'm saying is based on what I can see is what I can see.
If there's a dismissal order, then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, a court order is a court order.
I understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right? I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
Yes, Judge.
Okay, everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the 2nd and 3rd. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pre-trial, not anyone else. Do you understand?
Sir.
All right. Good luck, sir.
Thank you, Judge.
Good luck with your appointment.
Thank you, Judge.
Counsel.
Judge, just to be clear.
You know, that made my day so much better that it was muted. It made it so much better. Thank you, Neil. I can't believe how happy that was that it was muted, and I'm over there thanking Neil, and that just made my day. Again, happy birthday, Nancy. We're all glad to have you on the show. We're glad to have you here. Thank you, everybody, for listening to the Judge Fleischer clip. It was kind of a hard one today. You know, it's not as lighthearted as a lot of it is, but it was important. We're going to go ahead and get out of here, and we will see you guys tomorrow morning with Judge Fleischer again. All right.